Welcome everyone to RBHR's Employment Law Update. Thank you all for joining us today. For those of you who haven't met me before, my name is Kim Baker. I'm a HR consultant at RBHR Consultancy, and I'll talk you through the agenda of what we're going to discuss today. So the agenda for today's webinar will be as follows. We're going to discuss recent employment law changes, future changes, proposed changes, other news, subject access requests, training, reasonable adjustments. We'll do a summary at the end and then we'll have time to answer any questions. So essentially, employment law exists to protect the rights of both employees and employers. After taking part in today's webinar, you'll be able to reflect on employment law changes recently introduced and the impact they've had, understand the various employment law changes coming up in the year ahead, know what needs to be done now to prepare for these changes whilst ensuring compliance for changes already introduced. Be aware of the consequences of failing to act. Understand how written correspondence such as emails can land you in hot water with regard to subject access requests. So moving on to recent employment law changes. The national minimum wage. The new national minimum wage hourly rates are £10.42 for those aged 23 or over, £10.18 for those aged 21 to 22, £7.49 for those aged 18 to 20, £5.28 for those aged 16 to 17, or £5.28 again for an apprentice rate. So these changes came into effect on the 1st of April 2023. Although most employers are quite hot on the national minimum wage, there are still many common mistakes that employers make. So number one is failing to pay the national minimum wage following the annual increase. So even if you're working to the national minimum wage, it's always worth making sure that you've got reminders in place so that you're on target to meet the next national minimum wage increase as and when it comes around. Failing to realise the national minimum wage applies to all workers, not just employees. So anyone that you employ is subject to the national minimum wage. Missed birthdays. So if you're obviously paying somebody and they're aged 20 years old, the national minimum wage, it'll be £7.49. But when, of course, they turn 21, they need to be moved up to the £10.18 rate. So again, it's good to have reminders in place so that you don't miss those birthdays. Paying the apprentice rate to somebody who isn't actually an apprentice. So there's quite strict rules about what does constitute someone being an apprentice. So it's wise to follow those as well. Continuing to pay the apprentice rate for too long. So if somebody turns 19, for example, they won't be on the apprentice rate anymore. Making wage deductions for items or expenses that are connected with the job, e.g. company uniform. So making wage deductions that are deemed to be the employer's own use or benefit, such as a Christmas Club savings scheme. Not paying for all the time worked, such as travel time, shift handover, time to clear security, etc. Including elements of pay which don't count towards minimum wage, such as tips, and we'll come on to that again later on. Failure to pay for time spent undertaking mandatory training. So that should also be paid if someone's undertaking mandatory training. If an employee or worker has not been paid the minimum wage, they can make a claim to an employment tribunal or to HMRC. However, they cannot do both. The Low Pay Commission, LPC, is the independent body which advises the government on the levels of the national minimum wage, including the national living wage. And they're currently seeking evidence to inform recommendations on minimum wage rates in 2024 and beyond. So the consultation closes at 11:45 p.m. on the 9th of June. If you want to be involved with that, please go to the government.uk website and you can get more further information there. Statutory payment rates. So the statutory payment rates for maternity pay, paternity pay, shared parental pay, adoption pay, and parental bereavement pay increased on the 2nd of April 2023 to £172.48 a week. Statutory sick pay increased on the 6th of April 2023 to £109.40 a week, and statutory guarantee pay increased on the 6th of April 2023 to £35 per day. So for those of you not familiar with statutory guarantee pay, this is the maximum amount of money a worker can be paid during layoff or short-time working. And again, penalties can be imposed by HMRC or an independent tribunal if an employer fails or refuses to operate any form of statutory pay correctly. So statutory guarantee pay was more common prior to furlough being introduced to do with COVID. But of course, if you're potentially facing a redundancy situation because you've got less work than what you had before, you might impose statutory guarantee pay for a short period of time just to get you over some of the problems. And it may mean that you don't need to make redundancies as quickly, or you don't need to make redundancies at all because you can try and turn things around prior to bringing everybody back in under normal circumstances. So, like we said about statutory pay, penalties can be imposed by failing to pay statutory pay. However, this doesn't mean an employer can't make a mistake in paying a worker statutory pay, such as the national minimum wage, merely that should a mistake come to light, it's rectified without delay and not ignored. So from the 6th of April 2023, in accordance with the Employment Rights Increase of Limits Order 2023, changes to the current limits on tribunal awards came into effect as follows. So the statutory cap on a week's pay for calculating the basic award and statutory redundancy pay increased to £643. The maximum for an unfair dismissal basic award increased to £19,290. And the maximum award for unfair dismissal compensation increased to £105,707. And those changes occurred on the 6th of April 2023. Vento bans were established in the case Vento versus Chief Constable of West Yorkshire Police, in which the Court of Appeal set clear guidelines for the amount of compensation to be given for injured feelings. So, for example, a high ban, the most serious of cases, could refer to where there's been a lengthy campaign of discriminatory harassment, which has had a profound effect on the victim. So from the 6th of April 2023, the Vento bans for calculating injury to feelings awards in discrimination claims for England, Wales and Scotland are set at the lower band, £1,100 to £11,200. So again, that's for the less serious cases. The middle band is £11,200 to £33,700. So that's cases not meriting an upper band award. And the upper band, as we said before, £33,700 to £56,200 is the most serious of cases. Exceptionally serious cases could exceed the £56,200 gap. So essentially, these bands give employers an indication of how much they may be expected to pay out in the event of a discrimination claim. So when you basically receive your tribunal form. So for this purpose, the size or resources of the employer's business is not relevant because the award is only designed to reflect the effect on the victim. So strictly speaking, the Vento bans don't create a limit, so there is potential for injury to feelings awards to exceed the highest band, but that would be exceptionally rare. State pensions. So to cut costs, the official retirement age is gradually being raised from 66 to 67. And this change is going to take place between 2026 and 2028. State pensions also increased by 10.1% from April 2023. So the maximum new state pension has increased to £203.85 a week. So, but you may get more or less than this depending on your individual circumstances. So menopause and the workplace, suggestions were made by the Women and Equalities Committee for the government to reform the existing legal framework for employees experiencing menopause. However, they were largely rejected. The idea of a model menopause policy and a pilot menopause leave policy were also rejected because they were considered unnecessary. Making menopause a protected characteristic was also rejected, as it may have unintended consequences. But the idea of having a menopause ambassador was accepted. Helen Tomlinson has been appointed to this voluntary role, and the intention is for Helen to work with business stakeholders, unions, and advisory groups to encourage and disseminate awareness, good practice, and guidance to employers. Spring Budget 2023. This slide is just a snapshot of what was included within the Spring Budget. A new universal support programme will support disabled people and people with health conditions into sustained work, with those eligible able to opt in to receive up to 12 months of provision, with the government spending up to £4,000 per person and funding 50,000 places every year. It's thought this will help them to move quickly into suitable work, and with wraparound support help them sustain that employment for the longer term. Returnerships are targeted at adults over the age of 50 who are returning to work or seeking a career change. Apprenticeships and most skills boot camps are open to everyone, but sector-based work academy programmes are specifically for job seekers who are either claiming either universal credit, job seekers allowance, or employment and support allowance. The corporation tax will increase from 19% to 25% for businesses with taxable profits over 250,000. Businesses with profits between 50,000 and 250,000 will pay between 19 and 25%, and no change for businesses making profits of less than 50,000. The government is expanding the support and offer by providing 30 hours a week of free childcare for 38 weeks a year for eligible working parents of children aged 9 months to 3 years. This will be rolled out in phases from April 2024 and is in addition to the 30 hours a week already provided for eligible working parents of 3 to 4-year-olds. The future changes. Changes to flexible working. So flexible working helps employees balance their work and home life, especially if they have to care for children or vulnerable people. So changes to flexible working are afoot, with Employment Relations Flexible Working Bill currently progressing for the House of Lords, with the second reading due to take place on the 19th of May 2023, so that's this coming Friday. If passed, this would give employees the day one right to request flexible working. So employees can make use of job sharing, flexi time, working compressed hours, as well as hybrid or remote working. They'll also be able to make 2 requests in a 12-month period rather than the current one. And employers will have 2 months to respond to the request as opposed to the current 3 months. Under the Workers' Predictable Terms and Conditions Bill, this bill, if passed, will allow workers and agency workers to request more predictable terms and conditions of work. So this bill is more aimed at those on 0 hours contracts. However, it will apply to all workers. Employers will still have the option to refuse a request for a more predictable working pattern on specific grounds, so similar to what you can refuse a flexible working request for. So the burden of additional costs to make such as the burden of additional costs to make changes, or there being insufficient work at times when the employee proposes to work. Again, workers will be able to make up to 2 requests a year. Carers Leave Bill, that's a private member's bill that would amend the Employment Rights Act 1996 to give the Secretary of State the power to create by regulations a new entitlement to carers leave. So this unpaid leave would be available to employees who need to provide or arrange care for a dependent with a long-term care need. So dependents will include partners, children, parents, and people living in the same house as the employee. The new statutory entitlement would be a day one right, meaning that it would be available to employees no matter how long they've worked for their employer. And employers would not have to provide evidence in relation to any request for carers leave and will be able to take the leave in increments of half days or individual days up to at least a week over a 12-month period. So family-friendly rights. So these two bills were actually both in the pipeline before the pandemic. However, as with everything else, was delayed due to the pandemic. So the neonatal care leave and pay bill is a bill to make provision about leave and pay for employees with responsibility for children receiving neonatal care. So if passed, it aims to provide an additional 12 weeks leave for employees who are responsible for children receiving neonatal care, and will be available from the first day of employment in their job, and will apply to parents of babies who are admitted into hospital up to age of 28 days who have continuous stay in hospital of 7 full days. So basically what the bill is aiming to do is to stop mothers and fathers having to use maternity leave or the shared parental leave or paternity leave in order to care for their newborn baby. So the argument is that it can stop mothers from bonding with their baby because they're bonding in a care setting rather than actually in their own home. So all these bills have one thing in common: they're giving employees more rights, basically. So the Protection from Redundancy, Pregnancy and Family Leave Bill aims to make provision about protection from redundancy for pregnant women and new parents during or after pregnancy or after periods of maternity, adoption or shared parental leave. So if passed, mothers will receive an additional 6-month protection from redundancy. So the bill aims to help shield new parents and expectant mothers from workplace discrimination. So again, the bill is currently progressing through the House of Lords with the third reading due to take place on the 19th of May. So that's this coming Friday. So like I said, all the bills have one thing in common. They're all seeking to give more rights to the employee. So the Employment Allocation of Tips Bill is new legislation recently approved, which imposes unlawfulness for employers to withhold tips from staff. The simple aim of the bill is to ensure that 100% of tips and service charges are passed on to staff. So media reports have previously shown employers in the UK restaurant chains and wider hospitality industry taking a proportion of employees' tips. So this links into what we talked about earlier regarding national minimum wage, where employers cannot use tips to make up workers' pay to national minimum wage levels. So as with wages, deductions from tips for breakages and accidents could also be seen as unlawful too, and employers can face fines of up to £5,000 if their tipping practice is found to be unlawful. So what should employers do? So it would be a good idea for employers to have a written tips distribution policy which states whether they require, encourage or discourage tipping and states how tips will be distributed. Employees who regularly receive tips will also have to create a record kept for 3 years of how a tip was dealt with and understand how tips can be shared between non-public and public-facing staff. The Worker Protection Amendment of Equality Act 2010 bill is currently in the House of Lords at the committee stage. During the committee stage, every clause of the bill has to be agreed to and votes on any amendments can take place. So this bill aims to make employers liable for harassment committed against employees by third parties on their premises, including sexual harassment. So when the Equality Act 2010 was first enacted, it made employers liable for sexual harassment of their employees by third parties. However, there was a 3-strike rule. This new bill would reinstate employment liability without the 3-strike rule. So what does this mean? What can employers do to protect their staff? So ensure there are clear policies and procedures employers can use to demonstrate they have taken reasonable steps to prevent or avoid harassment in the workplace. Ensure that all staff have had training on equality and diversity when they join, and regular refresher training is given too, and carry out a risk assessment on the different types of roles and assess how they will interact with third parties. So, and consider updating websites and post notices in public places to demonstrate a zero tolerance to any form of harassment against members of staff. So I'm sure a number of you have been sat in a doctor's surgery or a coffee shop, and you've seen a notice in the window or somewhere in the building that would have caught your attention. And it talks about abuse of staff will not be tolerated. People will be ejected from the building if they incite violence or act abusively towards any member of staff. So that is a clear sign of an employer taking action to show that, you cannot abuse members of staff. It's not acceptable. We won't put up with it. So that's one of the reasons why you see those displayed quite regularly throughout doctors' surgeries, coffee shops, etc. So retained EU law revocation and reform bill is a bill before the Parliament of the United Kingdom that will revoke most legislation implementing European law in the UK, so-called retained EU law, so following the UK's exit from the European Union. So it was initially presented to Parliament in 2022. It was originally promoted by the government as the Brexit Freedoms Bill. The bill has run into significant opposition from many sources. Everybody's been moaning about it. Everybody's been complaining about it because it is a massive thing. So as of May 2023, thankfully, the government has decided to abandon the sunset clause in the retained EU law, the Revocation and Reform Bill. So in practice, this means the bill will be amended to contain a list of the retained EU laws that the government intends to revoke on the 31st December 2023, but anything not on that list will remain valid. So again, this was a major thing that on the 31st December 2023, a number of EU laws were basically going to be defunct overnight, and that would have affected women quite greatly, and also a number of other laws that are already in place. So at the moment, the potential changes could affect the working time regulations. For example, removing the requirement for record keeping. I know in practice few employers currently keep such records, so the removal of this obligation doesn't have much impact. In terms of 2P, employers will no longer be required to consult with appointed representatives when there are fewer than 50 employees in the business and fewer than 10 transferees. It will allow businesses to consult directly with the affected employees. There's also a plan to merge the currently two holiday entitlements into one, such as allowing rolled up holiday. So for those of you who are not sure what rolled up holiday is, rolled up holiday pay is a system where businesses include their workers' holiday pay in their basic pay rather than paying them when their actual holiday is taken. So it might result in an increase in the hourly rate by a couple of pounds an hour. And it helps to streamline the administrative process for the businesses, which do not then have to calculate a worker's holiday entitlement. So it's not clear if rolled up holiday will be allowed for all workers or just casual workers, but at present there's no set date for these changes. So proposed changes. The draft code on fire and rehire. This is intended to apply in situations where an employer is contemplating making changes to their employees' terms and conditions and envisages that if the employees do not agree to the changes, it may dismiss them and either re-engage them on the new terms or engage new workers on the new terms. So the code would apply irrespective of the number of employees affected or the employer's reasons for seeking to implement new terms and conditions, but not apply to genuine redundancy situations. So I'm not sure if you would remember, but last year there was quite a lot of controversy in the news about Elon Musk, where he, P&O Ferries, fired a number of employees and then replaced them with workers. And it was considered to be very bad practice, obviously not very nice for those involved. And the government has drafted the code of practice basically to to guard against things like that happening. So they're not saying that you can't do this. However, they're trying to make employees a bit more responsible for the actions they're taking. So the code requires employers to share as much information as possible with employees. It suggests the appropriate information to consider and requires employers to answer any questions or explain the reasons for not doing so. Essentially a bit more guidance on what is and isn't acceptable. So proposal to limit non-compete clauses. The government are wanting to introduce new legislation to restrict the duration of non-compete restrictive covenants to 3 months. Employers will still be able to restrict activities during paid garden leave or notice periods. The 3-month limit will apply only to post-termination covenants. Currently, there's no date for this change. So what this means is that basically, if I was to leave RBHR consultancy and go and work for another HR firm locally, I wouldn't be allowed to do so within 3 months after me having left the employment of RBHR. So again, this is giving more power back to the employees, because at the moment it can be up to 6 months, but it's restricting it to 3 months now, so it's changing it slightly. But there's no date for this change. If and when it does come in, we'll obviously keep you updated. So in other news, we had FitNotes. So this change occurred on the 1st of July 2022. FitNotes can only be issued following an assessment of a person's fitness for work. They cannot be issued on request. But basically what happened was more healthcare professionals were given powers to certify FitNotes. So before this, it was only doctors and GPs that could issue FitNotes. The legislation change also removed the need for a FitNote to be signed in ink. And that came in back in April 2022. So it's been around for a little while now. The 4-day working week, the report for the trial was published on the 21st of February 2023. 92% of the companies that took part decided they were going to continue with the 4-day working week. They said the work-life balance was improved, stress and burnout decreased by 71%. However, some critics argue that long-term effects are not clear and some industries cannot adapt to a 4-day working week. There was also a consultation on holiday pay, Harper Trust versus Brazil. The consultation ran from the 12th of January 2023 to the 9th of March 2023. So basically, it was a music teacher that only worked during school terms and had a 0 hours contract, and he had to take annual leave during the school holidays. So the case went to court, and the impact of the case was employers should not be using 12.07% holiday pay calculation for employees, which has been common practice for those on 0 hours contracts. So it basically applies to holiday entitlement received by part-year and irregular hours workers. Ethnicity pay gap reporting. So guidance was split into 5 parts: introduction and overview, understanding and reporting data, collecting ethnicity data, preparing payroll data, and making your calculations. So the ethnicity pay gap shows a difference between ethnic groups' average pay across an organisation over a period of time. Subject access request. So a subject access request, also known as a SAR, is a request made by an individual to access their personal information that is held by an organisation. So under Article 15 of the General Data Protection Regulations, so GDPR, an individual has the right to access any data which is held about them. So what does this mean in practice? Never write something in an email which you wouldn't want to be published online, even if you're sending the email confidentially. Consider how you would feel if the email was received by the person you're writing about. So also when responding to a SAR, consider what information is being asked for. So perhaps the employee or past employee is only requesting a specific document or a section of a document, rather than access to their whole HR file, and where possible, redact excess information. So ask them specifically what they're after. Is it a copy of their contract? Is it a copy of medical reports? You don't have to give them their whole HR file. It's fine to redact the excess information. So what should you do? Do contact your RBHR consultant via phone or Teams to discuss a way forward regarding exiting a current employee for the business. Please don't send us an email regarding an existing employee detailing how you wish to terminate their employment as soon as possible. Do consider confidentiality when dealing with information which is highly sensitive. Avoid putting this information in an email, adopting a face-to-face method of communication instead. Don't send an email containing highly confidential business information, which can be forwarded multiple times without your knowledge. Even when this email is deleted, it often remains stored on the server. Do, when responding to a SAR, consider what information is being asked for and where possible, redact the excess information. Don't reveal irrelevant data. Now I'm going to share a video of my colleague Emma Tones, our trainer, who couldn't be here today. She's put together a video for you all, so I hope you enjoy. So following on from what Emma Tones referred to in her video, ACAS has recently issued new guidance for employers on how to make reasonable adjustments at work for workers, contractors, or job applicants who are suffering from a mental health condition. So there are many types of mental health conditions, for example, depression or anxiety. Less common ones also include bipolar disorder and schizophrenia. Stress is not actually classed as a medical condition, but it can still be serious and cause or make worse other mental health conditions. So, for example, if you have stress over a long time, this might lead to anxiety or depression. Employers have a duty of care. This means they must do all they reasonably can to support their employees' health, safety and well-being. So changes can include changes to someone's physical working environment, changes to someone's working arrangements, finding a different way to do something, adapting the way policies are applied, providing equipment, services or support. So it might be that someone is suffering from a mental health condition and they work in an open plan office with a number of different employees, I don't know, up to 20 people, for example, and causing them more and more stress, more and more anxiety by being in that open plan office. So a reasonable adjustment might be that they work separate to the whole team so that they're not on an open plan floor and they don't have to work alongside quite so many people. They might prefer a smaller, more comfortable office environment. So to summarise what we've talked about today, it's important for your current HR policy to be legally compliant, up to date with current legislation, integrated, meaning each policy complements and supports any related policies. So any questions? So we have a question here. Do you have to be a registered carer to apply for carers leave? So employee may be a carer under the proposed bill following consideration of the employee's relationship with the dependent. So the dependent must be either, like we said before, a family member, a member of the same household, or otherwise must be someone who reasonably relies on the carer. So it's believed the dependent must also have a long-term care need and that they will likely require care for more than 3 months. Their condition constitutes a disability under the Equality Act, or they require care because of their old age. But obviously we're still waiting for the bill to be passed and for more information to come out. So we'll update you as and when we know more. How would you legislate as an employer against misuse of the carers leave policy? So the maximum duration of the leave and how and when it could be taken will be set by the regulations. Although the bill would require the leave entitlement to be at least 1 week per year. So RBHR would obviously work with all of our clients around the perimeters of leave and create template policies to assist you in how to implement once we know exactly what bill has been passed. So can they take the carers leave with immediate effect or is there a notice period? So if the bill is passed, carers leave will become a day one right available to employees without any qualifying period. As to whether you need to give notice, it depends on the parameters of the bill. So we'll wait to be guided by the legislation that is passed. Is carers leave for if children are just sick or disabled carers? So the unpaid leave is available to employees who need to provide or arrange care for a dependent with a long-term care need. Is the carers leave limited to 5 days unpaid a year? So yes, if passed, the carers leave will be limited to 5 days unpaid per year, despite the Carers UK campaign for it to be paid leave, it will still be unpaid. So if you would like to contact us, if you've got any questions about this webinar or need any HR support or advice at all, then our numbers are on the screen there, or you can email us at inquiries@rbhr.co.uk. Thank you very much for taking part in this webinar today. I hope you found it very informative.